Would everyone ensure, please, that all electronic devices are turned off or switched to silent mode? Tea and coffee, of course, are not allowed in the committee room. And we're continuing line-by-line consideration of the terminally ill adults end-of-life bill. And could I just ask people gently to try and abide by my exhortations from yesterday. So we now come to Amendment 322 to Clause 3 in the name of Daniel Francis, with which it would be convenient to consider Amendments 49, 50, 398 and Clause 3 stand apart. I call Daniel Francis to move Amendment 322. Daniel Francis.
Thank you, Chair. It's a pleasure to serve under your chairmanship. So, with regard to Amendment 322, I beg to formally move, and I accept we've had a long debate on issues relating to mental capacity on the amendments tabled by the Honourable Member for Richmond Park. However, in our oral evidence, we heard significant representations and concerns regarding how the Mental Capacity Act 2005 would work in relation to assisted dying. The purpose of Amendment 322 is to reverse the burden of proof in relation to capacity. In general, and rightly, as I've previously said, a person is assumed to have capacity unless it's shown that they don't. As we've heard, this is a deliberately low bar in order to preserve the basic human right to participate in society and ensure that normal daily life doesn't require us all to prove we have capacity every time we make a decision. However, the downside of this assumption is that in situations where there is limited or unreliable evidence, or where it is a very borderline case, the result will be that that person has to be assumed to have capacity. It's surely clear that this could put many people into real danger if this approach were taken with assisted dying. We should not be afraid to say that a person who is terminally ill is potentially vulnerable. We know that depression and stress are common and understandable responses to a terminal diagnosis. And whether we like it or not, we know that there are people in our society who will prey on the fragile for their own gain. It is our job here to confront the risk of somebody being given access to an assisted death, not because it is really their considered wish, but because there is no conclusive evidence available to the doctors at the time of the assessment. Or if somebody is controlling or coercing that person and is able to persuade them in favour of an assisted death that they do not truly want, simply by hiding any signs of their impaired capacity until it's too late. Now, previously under previous amendments, I did speak from my own personal perspective, and I think as a parent of a child with a learning disability, your greatest concern is what will happen to your child after you've gone. You know, that is the principal, sole thing I think that keeps my wife and I up of a night. What will be that determination for our daughter one day? And I hope that her twin will remain with her and her twin will be the person that makes those decisions for her. But I know, of course, that may not be the case. And I know that we may have to entrust the state or others to make those determinations for her in due course. And that, of course, is a determination that every parent of a child with a learning disability considers every day, and that I know is weighing on their minds, and certainly not only on this clause, but when we get to clause 4 later, will weigh on their minds about the decisions that their child, not in my daughter's case, she doesn't have enough capacity, but those people who do have enough capacity, and we know from the evidence the majority of people with a learning disability do have enough capacity, the decisions that may be made for them in due course. And in those circumstances, I suggest it is appropriate and reasonable that the assisted dying process maintains the other principles of the Mental Capacity Act, but reverses the presumption in favour of capacity in order to keep vulnerable people safe. We've heard that doctors are very familiar with the Act, including in cases where people sometimes do and sometimes do not have capacity. On that basis, it is not a great leap for them to look for evidence that a person does have capacity rather than the opposite. This is a normal exercise of their judgment. It's a compassionate and common sense approach. And I'll remind members of what I've said previously of the position of the Law Society, is that the issue of what capacity should mean and how to assess it is central to the bill. The Law Society considers that the bill should be clearer in its approach to capacity for the purposes of ending a terminally ill person's life. While expert opinion may reasonably differ on whether to use the Mental Capacity Act approach or introduce a standalone definition, the utmost clarity is required if the bill's safeguards are to be robust and effective. And their recommendation is that before this provision becomes law, a comprehensive consultation should be undertaken to allow relevant experts to share views on the appropriate definition of capacity for the purpose of this bill. And I won't quote them all again, I've quoted them previously, but we've heard oral evidence on this matter with concerns about how the Mental Capacity Act may be interpreted from Professor House, from Baroness Faulkner, from Fazlet Hardy, from Dr Hussain, from Chelsea Roth, from Professor Rowling, from Dr Price and Dan Scorer of MNCAT. I believe my amendment is a compassionate and common sense approach that would provide reassurance to members of the public, and I invite the committee to support it. I now, with your permission, Chair, turn to Amendment 398 in the name of the Honourable Member for Reigate. It goes further than my amendment, of course, and outside the scope of my amendment, but I do have some sympathies for it. And again, I'll repeat some of what I've said previously, in that I'll remind the committee of the statutory principles within the Mental Capacity Act, that a person must be assumed to have capacity unless it's established that they lack capacity. A person is not to be treated as unable to make a decision unless all practical steps, and that remains a grave concern of mine, to help him to do so have been taken without success. And a person is not to be treated as unable to make a decision merely because he makes an unwise decision. And I remain happy to stand corrected, as I've continued to ask for clarification on this matter, but my point that doctors or other professionals would have to take all practical steps to help an individual make a decision related to assisted death has not been challenged. This matter was clearly considered to some degree previously, given that Clause 62 of the Mental Capacity Act 2005 states, for the avoidance of doubt, it's hereby declared that nothing in this Act to be taken to affect the law relating to murder or manslaughter or the operation of Schedule 2 of the Suicide Act 1961, in commas, assisting suicide. I would also challenge whether the bill's authors have considered all scenarios outlined in the Mental Capacity Act Code of Practice, outlined in Section 3, how should people be helped to make their own decisions, particularly relating to the involvement of family members and carers. And Chapter 4, how does the Act define a person's capacity to make a decision, and how should capacity be assessed? And in Chapter 4, in 4.50, it does talk about for certain kinds of complex decisions, for example, making a will. There are specific legal tests in addition to the two-stage test for capacity, and those tests are laid out, but of course they don't include this scenario. And again, I refer, as I did yesterday, to the Equality and Human Rights Commission paper provided to members in advance of the second reading, which said a vital factor in determining how to manage access to assisted dying will be the concept of mental capacity in the context of a decision on this nature and gravity, of this nature and gravity. It will be important to ensure that all decision makers involved in the process have a full and clear understanding of the law around mental capacity under the Mental Capacity Act 2005. And sensitive consideration must be given in particular to the interaction between mental capacity, mental health issues, learning disabilities and conditions such as autism. And they state that Clause 30 of the Bill states the Secretary of State may issue codes of practice, but it doesn't oblige them to do so. So for those reasons, Chair, I remain concerned about continuing to use the full definition of the Mental Capacity Act 2005, and I therefore do make the amendment in my name, which is 322.
Thank you. Amendment 322 to Clause 3, as on the amendment paper. The question is that the amendment be made. Dr. Samanov.
Thank you, Chair, and can I thank the member for this really sensitive and well-presented amendment. A couple of things I'd like to say about this. He says that the Mental Capacity Act is a low bar, but actually in the Act it's important when we assess people for mental capacity that we look at the gravity and the complexity of a situation and therefore take more consideration of deeper understanding of the issues if the gravity of their decision is very enhanced. So I would say that there is scope within the Mental Capacity Act to take in these type of assessments in terms of assisted dying. Now,
Sorry, will the Honourable Member give way?
certainly, yeah.
And I hear that, and I hear, of course, there are different decisions, whether it's buying a coffee or, seeking assisted death. But would the member concur that for some individuals in those scenarios, who may be by themselves because of circumstances in life, and there may be doubt about their capacity, that A, the doctor must presume in the first instance they do have capacity, and secondly, that the doctor must assist them in making a decision?
Yes, I totally accept that, and I do think that the Mental Capacity Act is set so that we assume capacity and we look for evidence of lack of capacity. I think the great danger with this amendment is it changes a whole raft of very well used, and as Professor Whitty said, this is used up and down the country every day. I've used it myself many times, I've taught it as well, and I think if we change that emphasis from presumption of capacity to the presumption of incapacity, which is what you're suggesting, that is a major change in this act. Certainly, yeah.
Thank you, Chair. Thank the Honourable Member for giving way. Given what he just said, that he accepts the premise of the previous member that the doctor would have to assist, then where does that leave, and I'd just like to help me understand, where would that leave the issue of autonomy if a doctor is, as you've said and agreed, allowed to assist in that decision?
So the way the doctor assists, if you make a mental capacity assessment, is they try and tease out the four concepts, which is, does the patient understand what they're being asked to agree to or not? So the doctor, so sometimes mental capacity assessments last 5 minutes, it's very straightforward. Sometimes they last an hour. I've done one which lasted about 90 minutes because it was really important to tease out, does the patient genuinely understand what they're doing? So that is the sort of assistance I'm talking about. It's not about trying to persuade them to make a sort of decision that I think is the right decision. It's just making sure that they understand it and they can remember it, etc.
Would the Honourable Member turn up?
Certainly.
I'm very grateful for the Honourable Member for giving way. How does he respond to the Royal College of Psychiatrists, not one, not two, but multiple witnesses, saying that this Capacity Act, in objection to what he's saying, absolutely contrary to what he's saying, isn't the right bar? The bar's too low.
Well, that was disputed by other psychiatrists as well. So in that way, we're asking questions of whether this act is safe and correct for this bill. What I would say is I think this whole committee is about making this bill safe, all right? And I think none of us would dispute that. However, I think if we accept this amendment, this bill will become less safe because it's changing a massive piece of legislation, and therefore it will have a number of repercussions that we do not understand. Yes, certainly. Yeah, go on.
I'm very briefly. Chris Whitty made the same point that the Honourable Gentleman was just making, that there will be knock-on effects and that the Mental Capacity Act works very well currently, and it's a point that the Honourable Gentleman just made. Does he acknowledge that Chris Whitty himself misrepresented the Mental Capacity Act in the evidence that he gave to the committee, and he had to write to us subsequently to clarify his comment? And his clarification contradicts the point made by the Honourable Gentleman, the implication that the Mental Capacity Act has different thresholds for different levels of decision. Will he acknowledge that it doesn't? There's one threshold, capacity as defined in the Act. Some doctors may have longer conversations than others depending on the severity of the case, but the threshold is the same, and Chris Whitty misrepresented it.
I agree that the threshold is the same. Has the patient got capacity or has they not got capacity? That is the single threshold. What I would say is that on these types of grounds, so often we do mental capacity acts, for example, in terms of inheritance and of control of bank accounts and that sort of thing. And sometimes you do a very quick mental capacity act about refusal of treatment as well. So these things, so it depends on how important the decision is how long we take. Now, I would suggest that a doctor assessing someone's capacity to make a decision to end their life, that would be a serious, long discussion, as I say, up to 90 minutes, possibly even 2 hours, to assess, to make sure that the doctor is convinced that the patient has capacity. Now, the thresholds are the same. It's about have you got capacity or not. But that doesn't mean the conversation is the same. And so I think in clinical terms, it's very clear that a conversation on these grounds would be much more involved than, say, whether you see a dentist or not, or you know, those other things. So I do believe, and I think, and I totally understand the concerns that this amendment have been brought forward to cover. However, I feel that if we introduce this amendment, it will make the bill less safe, and that is my main point. And the reason for that is, as I have said before, if you change something that's well used and repeatedly used, that will make the interpretation much more complicated. We'll have to retrain all the doctors, and I think also it will not protect patients. Sorry. Yes,
at risk of repeating something that was said in a previous session of this committee, does he not accept that this amendment is not trying to amend the Mental Capacity Act itself, and it is not trying to change how the Mental Capacity Act is used in the majority of situations in which it is already used? All it is trying to say is, in this particular circumstance, it needs to be applied in a different way. We are not trying to rewrite the Act in itself or any aspect of the way that it's currently used.
I thank you for your intervention, and I think I understand what the amendment is trying to do. My argument here is that it won't achieve that, because it will muddy the waters of a mental capacity assessment, and so that it will make it less safe how we're doing it. Now, I would also like to come back to Professor Whitty's comments to say that in the majority of cases, it's very, very clear mental capacity. It doesn't actually take very long to assess a mental capacity, whether someone has mental capacity.
Can the member be allowed to answer fully the questions that the two members have asked before you intervene on another point? Sure. Simon Ofer.
Yeah, so I think it's really important to understand that the majority of people you can assess mental capacity reasonably quickly, because it's very clear whether they have it or they don't have it. I think what we're talking about here is a small portion of patients where it's unclear whether someone has a mental capacity. And I think there is scope within this bill that in those circumstances the patient should be referred to an enhanced level of mental capacity assessment by a psychiatrist or by a psychological nurse. So I think in that way it makes it much safer, and I would say that we don't need to redesign the Act for those small quantity of patients, because we already have a really safe route to assess that capacity. I'll give way again.
Thank you, Chair, and thank you. I thank the Honourable Member for giving way. He's been very generous with his time. Just to respond, I just want to ask whether, I don't know whether you've seen the evidence from Alex Rook-Keane, the KC, on the mental capacity, and one of the things he set out very, very clearly the myths around mental capacity. And one is that the mental capacity is well understood, and he argues that it isn't. So how would he respond to that? I
think in most cases, mental capacity is very, very well understood, and it's very clear, like I've said. As practicing clinicians, I would say that almost every GP has to do this, and actually I wouldn't sign up a doctor in training if they could not do this. So I think it's a little bit rich to suggest that we can't assess capacity. I agree with many of the comments that have been put about assessing capacity in more difficult cases, and I think we do need an avenue in that situation to get further opinions for most doctors. Do you want to take it?
I thank the Honourable Member. He said it would be rich for people to say that capacity can't be assessed. It's not. That's not the case. I'm not convinced that, and I'm not sure from the evidence that I've seen that anybody is saying that anybody is not capable of assessing capacity per se. What's the argument here, would he agree, is about assessing the capacity for this bill in particular, and that has not been tested. And that is what the Royal College of Psychiatrists are very clear, and many other experts, including legal experts, that this bill has not been tested for that purpose. Therefore, the Mental Capacity Act doesn't meet the purpose for this bill. Please.
I'm going to give people the opportunity to explore this, but as I've said, interventions are not mini debates. Simon Ofer.
I do feel, committee, that we have been through these points actually quite extensively, and clearly there's a disagreement in our beliefs in this, and I accept that. But what I would say is that it's very, very important to make this act as simple as possible, because that is the best safeguard. And I believe that the Mental Capacity Act is the right test to see whether people have capacity. And I'll reiterate it again, if there's a doubt in the clinician's mind, there should be an avenue to get an expert opinion around capacity.
Would you give way on that point?
Certainly.
Thank you, and thank you, Chair. Is he reassured, as I am, that we're focusing very much on one conversation here, but actually we know from the provision of the bill there will be multiple conversations, so one doctor, two doctor, psychiatrist, then overseen by an expert panel. So it's not just one assessment of capacity, there are multi-occasions. Does that reassure him and hopefully other colleagues?
Well, it does reassure me, and I think that it should also reassure other members of the committee, because 8 different people doing a Capacity Act is a very, very thorough safeguard around capacity. And I do feel that we have gone through these arguments many, many times in this committee. I do not feel that changing the polarity of mental capacity will do anything to make patients any safer in this situation. And that's why I do not agree with this amendment. And for fear of being interrupted anymore, I think I will leave it at that. So thank you very much.
Sir Olney.
Thank you very much, Chair. Thank you for calling me. Can I take this opportunity to apologise for being late to the session? Thank you for calling me to speak anyway. I wish to speak in favour of Amendment 50 in the name of the member for Runnymede and Weybridge, to which I have also put my name and plan to push to a vote. I'm conscious that we have gone through many of these arguments about the Mental Capacity Act in an earlier session and already in the speeches that we've already heard. But the reason I am keen to push this particular amendment to a vote is because I think it actually does answer some of the issues that have arisen. The point of dispute, if you like, appears to be whether or not the Mental Capacity Act, as it's currently operated for all the purposes for which it is currently used, for which I personally have no doubt it is a very, very effective piece of legislation and widely used and understood by clinicians everywhere, just as the member for Stroud was saying. The point at issue is whether it is the appropriate measure and the appropriate tool to use for this piece of legislation, for this decision that people are embarking upon, which of course is a decision like no other. And therefore, I think it is right and proper to consider whether the Mental Capacity Act is the appropriate way to measure whether people are able to make this particular decision. And I think it is it's useful to reflect upon the particular experience of the member for Runnymede and Weybridge who has drafted this amendment, and I'm conscious of the comments of the member for Ipswich yesterday about poorly drafted amendments. My understanding is that the member for Runnymede and Weybridge has extensive expertise in this particular area. He is an expert in the mental capacity assessment, and I dare say if he were in the room, he would have many useful and interesting things to say. However, I do think that's why his particular amendment does bear greater kind of weight, almost, to the extent that one member's amendment should be regarded as being any better than anybody else's. So the capacity test, and this is what's key to the Mental Capacity Act. It's the ability to understand, retain, use and weigh the relevant information. And the point about this amendment is it really does attempt to address what it means to make an informed decision. Now, Dr. Annabel Price, who gave oral evidence to the committee in her role with the Royal College of Psychiatrists, said that people who were planning to make this decision about seeking an assisted death would need to be able to understand the impact of the substance they are taking and what the likely positives and negatives of that are. And the informed consent process is different from a refusal of treatment. The informed consent process feeds into the capacity assessment. Now, this particular point came up in previous debates on this topic, and it is whether or not you can an informed decision about refusing treatment can be regarded as the same as an informed decision about wanting to end your life. Now, it's my personal view that these two things are quite different, and that therefore there should be a different standard of capacity brought to bear upon that decision. And I think the reason I support this amendment is because it does set out in detail how the Mental Capacity Act should be used specifically in relation to this decision. Not, as I said in my earlier intervention to the member for Stroud, not to change the Mental Capacity Act, not to tamper in any way with the ways that it is currently being used, but merely to specify the particular ways that it should be used in relation to this decision. It is, and I think it's important, and I hear what the member for Stroud said about doctors' use of the Mental Capacity Act. I heard, obviously, what the Chief Medical Officer said about doctors' use of the Mental Capacity Act. I'm very conscious of what the member for Bexley Heath said in a previous session about his own experience as the parent of a child who's often the variety of experience he has with professionals' understanding of the Mental Capacity Act, and I think that is something that has come across in a lot of the oral evidence. And as the member for East Wiltshire said, the Chief Medical Officer himself had to clarify the remarks that he made to the committee in his oral evidence. He implied that there were different ways of applying the Mental Capacity Act depending on the decision to be made, and there isn't. And that is a very clear clarification. So there is, I think, that implies that there is a difference in the way that doctors approach the use of the Mental Capacity Act, and we cannot have a difference of approach when it comes to a decision of such momentous importance as whether or not someone has the capacity to choose to end their life. And so I think there is a value, and I think that is reflected in this amendment, in attempting to standardise how the Mental Capacity Act should be used in relation to this decision, and that is why I think we should adopt this amendment. I think it's important on the face of the bill so that members of this House can make a clear statement that this is what they intend through this bill. It needs to be a clear statement what we expect doctors to do as they approach an assessment of capacity. We should specify the minimum of what needs to be understood for capacity for an assisted death. And that includes understanding the likely process of all treatment options, including non-treatment and prognostic uncertainty. Dr. Rachel Clark also in her evidence said, I would not be the first person to make the observation, sometimes, and I'm quoting here, sometimes doctors can be very pleased with their own abilities at a particular practice, and that practice might be having a conversation where you're assessing someone's capacity. So doctors have different assessments of their own ability to assess capacity, and that is why I think that standardised approach as set out in Amendment 50 is so important. And as I just really want to stress how important it is that Parliament should be the place where this setting the standards of what MPs expect as an assessment of mental capacity, we should be the ones to determine that and not leave it to the vagaries of individual clinicians. So I think it's important to say that the mental capacity, the assessment of capacity and the explanation of the treatment options to the person considering an assisted death, it needs to include the extent of prognostic certainty of their illness or condition. We spoke yesterday about the difficulties of knowing whether somebody's got 6 months or 12 months left to live. We don't, and how, to the extent you can be certain of the extent to which somebody is going to deteriorate and how much longer they may have to live. And again, we covered this in detail yesterday, what's the relevant and available care and treatment, including palliative care, hospice or other care. That needs to be part of the conversation about somebody's capacity to make this decision. And a decision to proceed under this Act, again, does not prevent or make unavailable any care and treatment provision that would normally be provided, so that it's clear that somebody has assessed the full range of their options. This amendment makes very clear an issue which I think is absolutely fundamental, which I don't otherwise think is covered by the Mental Capacity Act, or isn't covered to this level of specificity, that the decision to proceed must be theirs alone and not bound or directed by the views or decisions of others. Now, we've talked about the importance of that in relation to the bill as a whole, but I think it is really, really valuable to include that here as a specific requirement of assessing somebody's capability. I think doubts have been expressed across the committee about whether or not the bill goes far enough in assessing the extent to which somebody might be under duress or coercion. But to put it on the face of the bill as part of the capacity assessment, I think is a really, really important and essential safeguard. The fact, that having made the decision that they want to seek an assisted death, is the doctor or the assessing person confident that that person could then unmake the decision, that they would be able to change their minds at any stage.
I think, as my honourable friend has just said, there's 8 different opportunities for assessing capacity in this process. The last one being before the patient takes the medicine that will end their life. And so at all these stages, it's possible to stop the process and the patient is in total control. Can I also say that I don't disagree with any of the Amendment 50, but I do believe that everything in there is already in this bill under different clauses. So I don't think it adds anything to the bill, and I think it will actually make it more confusing to assess from a legal basis if this amendment is in place. Thank you.
I thank the honourable member for his intervention. On the first part of that intervention, what I would say is there are plenty of opportunities to change your mind, although I might slightly indelicate to point out that eventually there will not be a further opportunity. That's the point of what we're trying to do here. But that doesn't necessarily mean to say that the person then has the capacity to make the right decision at each stage of each of those opportunities, and that is what the doctors will need to assess. But I'll just go back to my earlier point, saying I think it is important that Parliament specify, by way of this amendment, precisely what they mean by assessing capacity. And I think it is important in the context of all the evidence we heard that there are not necessarily it is not necessarily a kind of a standardised approach across the medical profession, that the standardised approach is specified in the legislation, and this is the appropriate place to specify it. I think the other major point that I think is really, really important is that patients need to understand the process by which this assisted death is going to be enabled, and that obviously within the elsewhere in the bill it is laid out that it will be by the ingestion of an approved substance, and I think it is important that we really do understand exactly what that means or what it might mean, and I think we will doubtless get on to talk about the approved substance and the proper legislation around its use, but. It is really, really important that they are, and I think one of the concerns that was raised, and we didn't actually, to my mind, speak much about the use of the approved substance during the oral evidence sessions, but it is important that people understand that any medical procedure can fail, including an approved substance in this case, and we don't know how long it will take to be effective. We don't know what the patient's experience will be having taken the approved substance and how long that period will take. And it is important that they understand, to the extent that that it is possible for a doctor to give them that information, that is what they are undertaking. Professor House, in his evidence, said it's a striking feature of the bill that informed consent is not really specified properly. The doctor is required to ask the person what they want to happen in the event of complications without having previously explained to them what the complications might be. There's no standard informed consent form related to the bill, for example, of the sort you would expect to sign if you were having a serious intervention in the NHS. So it's something that he said was very underspecified in the bill. And I think that's why it's important that this particular amendment can actually start to address that it is really, really important, the capacity to understand what they are undertaking, not just that they are choosing an assisted death, but also all of the risks and complications that might potentially be attendant upon it. So for all of those reasons, I think it is, as I say, I just want to come back to my opening point, if you like, that it is important that Parliament specify a standard by which mental capacity can be assessed in relation to this specific decision. And I feel I've made this point a number of times. Just very quickly, one more time, we are not proposing to rewrite the Mental Capacity Act or tamper in any way with how it is currently used. We are merely setting a higher bar, a higher standard of how it should be applied in this particular case because of the very, very specific nature of the decision that is being that patients are being asked to make around this particular circumstance. Thank you, Chair.
Thank you. Shah.
Thank you very much, Chair. I'm going to be picking up on some of the points certainly Member for Stroud referred to, given his expertise on this issue. We heard from 3 senior psychiatrists during the evidence sessions who were very, very clear, and I'll just quote some of them because I've mentioned lots of this before, but in particular I have referenced some of this evidence, that it is the Royal College of Psychiatrists' view that the Mental Capacity Act is not sufficient for the purposes of this bill. Extensive consideration needs to be given to what an assessment of mental capacity should consist of for assisted dying prior to the passing of legislation, and indeed whether a determination through such an assessment can be reliably arrived at in this novel context. In their written evidence, in referring to assessing the capacity to end one's life, it is entirely different to assessing for the capacity of deciding treatment. This bill moves us into new territory by creating, we need to be moving into a place where we have a definition which meets the criteria, what we're assessing, which is to end one's life. That has never been applied in this country. The Mental Capacity Act, as it is, requires assessors to presume someone has capacity until incapacity can be proven, as the Honourable Member for the Moving Amendment has referred to, Amendment 322. Dr. Annabel Price, Professor Alan House, Professor Gareth Owen, all of them have expressed doubts about the use of mental capacity to assess whether a person was in a fit state of mind to undertake assisted dying. And there will be no opportunity to really change this. And there is a worry, because there's nothing in the current medical assessment that requires careful exploration of these factors, that there is no opportunity to change them. It is outside of the experience of the Mental Capacity Act, the Court of Protection, the associated research and practitioners on the ground. When looked at the Mental Capacity Act in lots of detailed research, there is no such experience, according to Professor Gareth Owen. The reference to Mental Capacity Act in Clause 3 puts us into an area where there is no experience of the central capacity issue under consideration. And again, I've said this before, his words were, it is very important that Parliament be clear-eyed about this. Further, Professor Owen said we are in uncharted territory because these are very novel ideas in relation to this bill. And that is the hub of this bill. It requires assessors to again assume capacity as a starting point, which isn't what this bill, to make it the safest bill in the world, that's not the measuring yardstick that we should be applying, according to very senior psychiatrists across the country. Alex Rupp-Keane, the KC, has also provided evidence to this committee, and some of the myths he set out in a video, which again, the evidence has been provided to this committee. And bringing it back to the, there's a few things in this for me. One is the article in the Telegraph, which again, senior psychiatrists alluded to, suggested that there was actually a shortage of specialist psychiatrists. So we've already had the conversation about the shortage of judges, but we've also now having a conversation about the shortage of psychiatrists, should this be in the bill as it is in any case. Now, I'd really value understanding from the Minister at the end of this whether that is something that has been assessed, given that we don't have an impact assessment. Dr. Alex Rupp-Keane has also referred to the National Institute of Health Research funded in 2022 a number of research projects under the umbrella implementing the Mental Capacity Act in practice. And the rationale being that the Mental Capacity Act is designed to empower and protect people who may lack the mental capacity to make their own decisions about their support and treatment, ranging from everyday issues to more serious life-changing decisions. Evidence has highlighted several aspects of the way the assessments are being carried out which are not compliant with the Mental Capacity Act. So if we have the Act as it is, and there are issues with how this is being implemented in everyday work of the NHS, of psychiatrists, then how much longer will it take us if we're to use the same Act, if this bill went through? How many mistakes will be made? How much potential is there for mistakes to be made when assessing for capacity for those that are most vulnerable? The Care Quality Commission, in its most recent State of Care report in October just of last year, said the Mental Health Capacity Act directly affects the lives of millions of people. Everybody providing care to over the age of 16 must be familiar with this vital piece of legislation which introduced rights and protections for people which may lack mental capacity. A decade after the House of Lords report, we continue to find a lack of understanding of the MCA among providers. This is the most recent research which is telling us that actually we haven't got this right with and this is an act that was enacted over 20 years ago. In 2005, we have the Mental Capacity Act, which still 20 years later is not being applied and is not understood for the reasons it set out for us to understand. If we haven't got that right in 20 years, how can we as a committee be assured that this will be applied to something that it has never been applied to, that has not been tested? How can we say that we should be rejecting this amendment which would change and raise the bar for people? Because ultimately, this affects people who are vulnerable. And I'll come on to the next amendment, in the next grouping of amendments, to talk a bit more in detail about that, Chair. But this is a real concern, and this is why I would urge members of this committee to support this amendment if we are to get these safeguards right. We spent hours talking about capacity, and those amendments in the first clause, those amendments weren't accepted, and we're not. And in this one, it protects. It comes from it's spoken to from experience. And I really, really appreciate the members' personal experience of this, because that is the reality. And again, we're not the experts, but we should be relying upon experts who give us the witness testimonies.
On that point, will the member give way?
Happy to give way.
Thank you, Chair. In the evidence we heard from MENCAT and in large swathes of the written evidence, we hear grave concerns from community representing people with learning disabilities about how this was enacted during COVID, particularly do not resuscitate notices, which shows that people with learning disabilities were far more likely to have those placed upon them. So can the member comment on that, and whether she thinks, the evidence we have, particularly in written evidence, is that that's either due to a misinterpretation of the Mental Capacity Act or bias within the medical community. So I don't know if the member's got comments on that matter.
I thank the honourable member, and he makes a very, very valid point, because the other thing is, we haven't got to it yet, but we will be looking at those doctors who decide they don't want to take part in this process. So will there be, and he's absolutely right to point out, and it's something that we must consider, will there be a bias? Will there be a subconscious bias towards helping? And when the honourable member for Stroud earlier suggested that they assist according to the Mental Capacity Act, it's assisting a person to reach the decision. And usually, and again, this is where the crux of it for me comes in. When you're assisting the person for their best interest to come to a decision, to take in treatment, for example, that's a different test to what we're testing here. And that really, really speaks to the nub of this issue for me.
Will the honourable member give way?
Happy to give way.
I thank you for giving way. And I share concerns with the member of Bexley Heath around use of DNRs. Of course I do. It was a disgrace what happened, particularly people with disabilities in COVID. But does she accept that this is an entirely different situation, in that people must actively seek and tested multiple times and expressed the wish, whereas the DNR situation was medical professionals making decisions on behalf of a patient without their input? Does she accept that's entirely different?
I thank the honourable member for his contribution and his intervention. I will be speaking to that in the next set of amendments. I don't want to go through it in detail now. But what I would say is that was, yes, I absolutely accept those were disgraceful situations. And I do accept...
Just address through the chair, please.
Sorry. I also accept that, apologies, Chair, I also accept that he is indeed right that there were different situations. But I also would remind him of the evidence that we heard from Dr. Jamila, for example, because the things that happened in COVID, and I'm glad he's actually reminded me, the things that happened in COVID were, whilst different set of circumstances, COVID and the expectation of the DNRs and that what happened, in his words, the disgrace, which I agree with, that is where the trust has been lost with NHS providers. That trust is no longer there. And if you do not have that trust, now come on to, which leads me on to my next point, which is actually when people don't have the trust, then they have a vulnerability. That vulnerability in turn it affects the capacity issue. And that again brings me on to what the Alex Rupkeen has been saying in terms of if there is that vulnerability, if people feel, as they did during COVID-19, that they have been DNR'd and they are now going to be, and again I'll talk about it in the next set of amendments, they are now going to be killed off, as people have said, they're going to kill us off, then that vulnerability directly impacts on the capacity of that person. So that's why I actually do accept what he's saying. It's different situations, but the argument is very, very strong about amending. It actually speaks to supporting this amendment and not the other way around. There is another myth of mental capacity is well understood. So it's not that, so that myth we've already gone through. There's a lot of myths about mental capacity, I tell you. So there is a mental capacity is always difficult, according to Alex Rupkeen. And what he's saying is 85% of capacity determinations that who actually understand the law are relatively straightforward, which would concur with the Honourable Member for Stroud, with difficulty arising usually because of not having enough time or not listening to the person. So there was some research conducted, and what it concluded, the experience of liaison psychiatrists, an interview study across 3 jurisdictions, and the 4 key sources of difficulty in capacity assessment spanning both clinical and ethical domains. And these were the 4 points, Chair. Difficulty to determine whether the decision is the patient's own or driven by illness. And that's an important one, because here we're talking about people who are terminally ill. So those decision-making processes, because they are terminally ill, or because perhaps there is a vulnerability, and a number of them could be possible, that becomes difficult. So those 15% that he's talking about, where it's difficult, includes that. Difficulty in applying ethical principles, difficulty in avoiding personal bias. And again, it speaks to the member of Bexley-Heath's intervention, that if we have these doctors who are already signed up to and believe in this, because lots of doctors are saying, majority of psychiatrists, actually according to the last article that I read, are saying they don't agree with this. So will they have a personal bias? So that is the third difficulty that Alex Ruckleen talks about. And procedural difficulties, lack of engagement, lack of information to verify facts, interpersonal conflicts between patient and the team when please assess capacity, believes therapeutic concerns. So these concerns speak to what is wrong with this bill as it is, which is why I will be supporting the Honourable Member from Bexley-Heath's amendment, and I would really urge everybody in this committee to support that, because the idea that mental capacity is enough with the Mental Capacity Act as it stands doesn't wash. And I'll finally, the fifth myth buster, if you like, and I'll read it out. The inherent jurisdiction can be exercised in relation to a vulnerable adult who, even if not incapacitated by mental disorder or mental illness, is or is reasonably believed to be either under constraint or subject to coercion or undue influence, or for some other reason deprived of the capacity to make the relevant decisions, or disabled from making a free choice, or incapacitated or disabled from giving or expressing a real and genuine consent. And that was the case in the court, Mumby J in RESA, Vulnerable Adult with Capacity, and it was Marriage 2005 case chair. And the answer was no. So that case in itself really, really does bring home the issue with this bill as it stands, as it is drafted. And it's not drafted, it's not set for this purpose. So I would hope that people will support the Honourable Member's amendment. Thank you, Chair.
Rebecca Paul.
Thank you, Chair. I'm going to speak on my amendment 398, and I recognise that much debate has taken place already with respect to capacity. So I will do my best to not be too repetitive, but it is an important topic, so I do want to cover a few things. Fundamentally, I consider the bar for capacity for making a decision to seek an assisted death to be far too low, as we've already discussed today, if the current approach is adopted as proposed by this bill. The committee has received powerful written evidence that the Mental Capacity Act as it stands is not suitable for assisted dying. So the Royal College of Psychiatrists say in their written evidence, and I quote, "It is not the Royal College of Psychiatrists' view that the Mental Capacity Act is not sufficient for the purposes of this bill." Baroness Hollins, former president, says the Mental Capacity Act has proved very difficult to implement and doctors have not been found to be good judges of capacity. The eating disorders expert Chelsea Roth says the MCA is not fit for purpose for determinations of capacity in life-ending decisions. I think it's not contentious to say that there should be a higher standard for ending one's own life than for other courses of action. Baroness Hale has called the Mental Capacity Act standard, I quote, "not a demanding threshold." The Royal College of Psychiatrists say in their written evidence, while we are of the view that a person's capacity to decide treatment can be reliably assessed, an assessment of a person's mental capacity to decide to end their own life is an entirely different and more complex determination requiring a higher level of understanding. Even if the Mental Capacity Act is working well in some other contexts, that does not necessarily translate well to assisted dying. Professor Gareth Owen told the committee in oral evidence that although the Mental Capacity Act is quite reliable in current practice, and I quote, "in areas of decision-making where the decision itself is unsettled or conceptually more profound or novel, I would suggest that the decision to end one's own life has those characteristics. You cannot expect there to be such levels of reliability." The Mental Capacity Act definition of capacity was not created with such a monumental decision with respect to assisted dying in mind. So although I note Chris Whitty's recommendation that it is the starting point, I don't think it can be the end point. Further provisions are needed to ensure it is fit for purpose, given the significance of the decision being made. Professor Owen said, and I quote, "I have looked at mental capacity a lot in research, and there is no experience of the decision to end one's own life. It is outside the experience of the Mental Capacity Act, the Court of Protection, the associated research and practitioners on the ground. The reference to the Mental Capacity Act in Clause 3 puts you into an area where there is no experience of the central capacity question under consideration. It is important that Parliament be clear-eyed about that." Dr. Sarah Hooper, a retired oncologist, says, "The patient in question may undoubtedly have capacity for the most important decisions. However, in the early days after a cancer diagnosis, their ability to make clear judgments is nevertheless likely to be impacted. This kind of decision for assisted suicide, once acted upon, is plainly irreversible. It is a very bad time to make that kind of decision." It's true that the Mental Capacity Act is used for decisions to stop life-sustaining treatment, but as Professor Owen said, we shouldn't simply equate that with assisted dying. As he pointed out, one, and I quote, "One is a refusal, one is a request. One is traditionally considered to be about bodily integrity. It is the so-called shield of the person or the patient against the intervention on the body that this being made by the medical profession. You are giving the patient an important right, which is a shield-like right. That contrasts with a request for assisted dying, which is a request. You are involving other people in an act that is an act of ending one's life. That is not something that the medical profession has been comfortable with going back thousands of years." I would also like to draw attention to a great deal of written evidence making the point that the current Mental Capacity Act isn't as well understood by medical practitioners as we hope or expect. Alexander Elphinston, a retired solicitor, says, and I quote, "From my experience, doctors and other medical practitioners often applied the test of mental capacity incorrectly." And Victoria Wheatley, a palliative medicine consultant, says, and I quote, "I have observed a tendency to overestimate a person's mental capacity in the absence of obvious features to the contrary." Alan Thomas, a professor of old age psychiatry at the University of Newcastle, says, "The preferences of the assessor bias the capacity decision towards the assessor's preference." I'll now move on to the specific issues with the current definition of people who lack capacity under the Mental Capacity Act when applied to assisting dying, all of which my Amendment 398 attempts to address. Part of my amendment does exactly the same as the Honourable Member for Bexley Heath and Crayford's Amendment 322, which he has already eloquently spoken on, so I will be brief on the overlapping bits. Firstly, under the Mental Capacity Act, there is a starting presumption of capacity. This is too lax a standard, as the Royal College of Psychiatrists says in written evidence. And I quote, "The presumption of capacity may be problematic in the context of assisted dying, given the consequence would be the person's death. Given this is literally a matter of life and death, the presumption of capacity must not apply, and the work must be done to assess capacity properly and thoroughly." Professor Preston in the evidence session said, "I think the aim is to have that bit of extra concern so that we do not presume capacity, but instead almost presume that there is not capacity." I think those are wise words, and my amendment and Amendment 322 seek to give this protection. Secondly, both amendments do apply Section 1, subsection 3 of the Mental Capacity Act on helping a person make a decision. The member for Bexley Heath and Crayford has already made his point powerfully on this, so I don't think I can add anything further. The next changes are where my Amendment 398 goes further than 322. Firstly, given the uniqueness and irreversibility of this decision, there should also be a higher threshold of probability, in my view. As it stands, a person should be treated as having capacity if that is more likely than not. This is sometimes referred to as the 51% sure approach. It would be much safer if doctors and judges have to establish beyond reasonable doubt that an applicant has capacity, given the significance of this decision. 51% sure is just not good enough for such a monumental decision in my view, and amending this part would ensure a more rigorous and comprehensive assessment. Secondly, and this is one of the biggest issues for me with the current approach, the Act requires an impairment of or a disturbance of the mind or brain for someone to be considered to not have capacity, irrespective of whether they can make a decision. So, under the current bill, even if someone can't make a decision, so they can't understand the information, they can't retain that information, they can't use that information to make a decision, they can't communicate that decision, they will still be deemed capacious in the absence of an impairment of or a disturbance of the mind or brain. So in the real world, a doctor could assess a patient who gives the impression of being confused, illogical, erratic, inconsistent. Everything about them could scream that they're not in a good place to make this decision. But they will still be considered to have capacity if there's no identifiable impairment of or disturbance in the function of the mind or brain at that point in time. This potentially puts those with depression, anxiety, learning disabilities, eating disorders, or even just those in physical pain in danger of being considered capacious. In oral evidence, Professor Alex Rutkin said, and I quote, "If I doubt that you have capacity to make the decision to take your own life or end your life, but I cannot prove it, is it logical, or are we required to proceed on the basis that you do? In other words, I think you cannot understand the information, but I cannot provide the reason that you cannot understand it, is that you have an impairment or disturbance." According to Professor Gareth Owen in written evidence, this means someone could be approved for assisted dying even if they did not understand the relevant information, as long as they do not have an identifiable impairment or disturbance in mind or brain. As Professor Owen said, and I quote, "The committee may well feel that it would be problematic that such a person should be considered to be eligible for the receipt of assistance in dying." In a letter to Sarah Olney, Professor Alex Rutkin, KC, says, "No matter how intensive the scrutiny of the person's capacity, this would not address the issue of the situation where the person appears not to be able to understand, retain, use and weigh the relevant information, but that is not caused by an impairment or a disturbance in the functioning of their mind or brain." And that is why my amendment seeks to remove this diagnostic element, so that Section 2, subsection 1 of the Mental Capacity Act, for the purposes of this bill only, would read as, "A person lacks capacity in relation to a matter if at the material time he is unable to make a decision for himself in relation to the matter." This would provide better protections for this life and death decision, and I hope it addresses the issue raised so powerfully by Professor Alex Rutkin, KC. As I close, I'd like to make reference to the member for Runnymede and Weybridge Amendment 49, which sets out starkly the deficiencies of the current capacity test if it remains unamended for the purposes of this bill. If autonomy is what counts, and we are using the Mental Capacity Act as gatekeeper for assisted death, then this current bill means that a person is assumed to have capacity as a starting point. A clinician only needs to be just over 50% sure that a person has capacity. Unwise decision-making is not taken into account in determining capacity. And supported decision-making is acceptable, for example, for those with learning disabilities. So I ask you all today, are you comfortable with that? If not, then as a minimum, Amendment 322 should be accepted, but ideally mine, Amendment 398, which goes even further to increase the threshold for capacity and addresses the significant issue with the diagnostic leg of the test. I'm also pleased to say that Baroness Finlay also supports my amendment, and she established the National Mental Capacity Forum and chaired it. Unlike this current bill, my amendment does require that a person is not assumed to have capacity in the first instance. It does require capacity to be proven beyond reasonable doubt. It does require that unwise decision-making is considered in assessing, and it does require that a person is not helped to make a decision. I hope you'll therefore all support it.
Tony Kruger.
Thank you, Mr. Chairman, and I'm very pleased to follow my honourable friend, who I think set out with incredible clarity the challenges here and the opportunity we actually do have to build on the Mental Capacity Act and to fulfil its purposes and to fulfil the purposes of the bill to ensure that capacity is properly assessed. I just want to start by, and I'll speak to all the amendments in the group very briefly, and I certainly won't repeat material points that have been made. And just to clarify, Mr. Chair, I don't propose to push Amendment 49 in the name of the member for Runnymede, although I'll speak to it briefly. I hope we'll vote on the other amendments. A very important point was made, or rather a confusion was aired in the course of the debate about the degree to which the bill currently is simple, according to the test set by Chris Whitty, or whether the bill is thorough in its provision of assessment opportunities. And I'm unclear whether the sponsor of the bill and the member for Stroud and others who spoke about this are themselves clear, because we heard that there are 8 moments in the current bill when capacity is assessed according to the Mental Capacity Act. I'm unable to find 8 moments at which a patient will be present and a proper Mental Capacity Act assessment will be performed. There are 4, as far as I can see from the bill. There's the first doctor's assessment, the second doctor's assessment. There's when the doctor witnesses the second declaration, and then there's the moment at the very end when the drugs are administered. Those are 4 moments at which the patient will be present and the doctor must be satisfied that capacity is present. So it's not 8, as far as I can tell. More crucially, these are not assessments in any defined sense. We expect the doctor to confirm there is capacity, and one hopes that will be done very, very thoroughly, even taking 90 minutes. Or possibly even longer, as the honourable gentleman was suggesting. But it's not clear from the bill how this assessment will be conducted. There is just the expectation that capacity will be confirmed. And whether it's 4 or whether it's 8 or whether it's 20, the fact is all of these assessments currently operate under the terms of the Mental Capacity Act. That's the simple purpose of Clause 3. And the contention of those of us who are requesting additional tests to be applied to build on the Mental Capacity Act, if we can't replace it altogether with a proper test of ability, as we'd hoped, is to ensure that a proper assessment is done that goes further than the frankly low threshold of the MCA. And I hope I'm not going to be repeating any evidence that's been brought before the committee already in this debate. I'll be brief here, but I want to absolutely scotch the suggestion that the Mental Capacity Act is clearly understood by all clinicians, that it's a tried and tested, well understood, coherently applied, universally interpreted piece of legislation. Because even though that may be the case for many doctors, let's even say the majority, there's clearly, just in the fact of the debate that we're having today, clearly a division of opinion on this, which itself is enough of a reason, in my view, to build further safeguards in, to ensure that if we're using the Mental Capacity Act, it's used properly and appropriately. So let me just give a couple of pieces of evidence from the evidence that we heard that has been presented to the committee. The chair of the National Mental Capacity Forum, which my honourable friend referred to, cites from their annual report from last year lack of awareness and a lack of understanding among doctors about how the MCA applies. There was a study from 2021 in the Journal of Medical Ethics that found, I quote, significant variation in practice by doctors, low self-confidence in the practice of MCA assessment. There was a literature review, happy to give way.
I'd just like to point out that, tightening capacity assessments, etc., which is what this is trying to do. Can I just point out that there are a number of amendments coming up about mandating training for assessing capacity, for example, which is an Amendment 186. And I think that during training for this, that would be put in place for the doctors who are registered to do it. And the other thing is that Amendment 6 would mandate psychiatric referral if there's any doubt to capacity. So does that not satisfy you? Sorry,
It pleases me, but it doesn't satisfy me. I'm encouraged by that, but I'm not fully satisfied. Obviously, that's insufficient. I mean, the honourable gentleman and the honourable lady put great faith in the training that we're going to introduce. Well, I hope so. Certainly, let's do as much training as we can. Likewise, let's get as much data as we can. But this is not sufficient. not least because the training will be in the application of the Mental Capacity Act, which we're saying, even if properly applied, has all sorts of problems with it, as my honourable friend was just explaining. So yes to that, and of course yes to the option of the referral. That should be mandatory. And I think, in fact, there is a proposal to affect that. So every additional safeguard is welcome. It goes back to my point about whether we're being thorough or simplistic here. I'm not sure. I mean, if there are 8 assessments, I think there are 4, but if the Honourable Member thinks there are 8, I mean, doesn't that fail Chris Whitty's test of being simple? And if 8 is in fact thorough, wouldn't 9 be even more thorough? So, I mean, the suggestion that we've hit the absolute perfect sweet spot, and that to veer one side is to introduce all sorts of bureaucratic hurdles, feels unrealistic to me. I mean, surely we can apply a little more rigour to this exercise. Happy to.
I thank you. Now, I know we've interacted before about the fundamental difference on the ventilator test, as I would say, in terms of someone saying, tested at the moment of turning off their ventilator, I want to die, please turn off my ventilator, as on, I want to die, please let me take this substance. Yeah. Can I just ask him, you know, while we may have a fundamental difference of those things being the same or different, if he still thinks it's appropriate for the Mental Capacity Act to be used as a one-off test with no other safeguards for the turning off of the ventilator, and why that's appropriate, but it isn't when tested multiple times in this instance.
Well, I'm grateful to him, and I recognise this is a vital point, and I'm not surprised we're going to probably keep returning to this important distinction. I do think there is a vital distinction between accepting a treatment and declining a treatment. I wouldn't, in fact, say the treatment that's proposed here is not a treatment at all, and the BMA specifies this is not a medical treatment at all that's being proposed. The termination of life deliberately is not medical treatment. It's not appropriate. It's not applying to a particular condition, which a ventilator is, or any treatment that one might decline or withdraw is specific to a particular condition or illness. So there is a difference in purpose, what it's for, even if the effect, of course, is the same, which is death. To his point, whether the MCA is appropriate in cases of withdrawal of treatment, well, there we do seem to have a substantial body of clinical practice over many years that I'm not aware of many objections to. And so my non-expert view is that it's probably appropriate to continue with the MCA in those cases. So I don't have an objection there, and I'm certainly not making that argument. It may well be that it is appropriate to, I'm sure we are constantly reviewing the applicability of that particular test in those circumstances, and it might well be that, in fact, some of the problems that I'm identifying with the proposed law might also apply in cases of withdrawal of treatment, but I'm not aware of those, because I do think they are substantially different. But even if there were even if it was the case that it's perfectly acceptable to apply the MCA in cases of withdrawal of treatment, that doesn't mean it's appropriate in this case, because they are fundamentally different scenarios. But I'm grateful to him, and I don't detect that I've satisfied him, but it's always good to have that exchange. Okay, so I'll quickly conclude my challenge to the suggestion that the MCA is universally understood and properly applied. And just with this observation, it's a case that's been referred to a number of times in the course of the debate about the case of Patricia in the Court of Protection, a patient with anorexia nervosa. We had evidence from a group of anorexia sufferers who wrote into the committee to say that the judge in the Court of Protection case of Patricia stated that he had changed his mind several times while considering the evidence. He then came to a different view on capacity from the treatment team. This single case exemplifies how complex the process described in these clauses in relation to assessment of capacity are likely to be. So we are not talking about a straightforward process, and it is clear, in my view, from all the evidence we've had that there is a real problem with the way the MCA would apply. And I want to quickly just make a rather obvious point, which is that when the MCA was debated and passed 20 years ago, assisted dying, assisted suicide wasn't on the table. It wasn't part of the consideration in that bill, as far as I'm aware. It does turn out, as I mentioned in an earlier session, it turns out dignity and dying were on the case back in those days. I think they were still called the Euthanasia Society then, around that time. But they were conscious of what would come. I don't think others were, and they're quite pleased now, I detect, that the influence that they applied, or others did, to ensure that this test, this presumption of capacity, would be very useful one day when it came to passing an assisted dying law, and that's the case. But that was not the intention of the House of Commons, not the intention, I believe, of the committee that considered that bill. That in fact they were establishing a test that would be applied in the case of assisting with suicide and changing the terms of the Suicide Act. I'm sure that if that had been the case, it would have been commented on, and indeed, I dare say the Act would not be in its current form, or there would have been some sort of addendum to that effect. Now, my honourable friend has referred to the very powerful evidence from lawyers, from Baroness Hale, from the Royal College of Psychiatrists about the challenge here. And I just want to quickly say in support of the honourable member for Bexley Heath and Crayford's amendment, the very, very powerful argument my honourable friend made about impairment, very, very striking, that the MCA only applies when there are cases of impairment or disturbance or functioning of the mind or brain. I won't repeat the point she made. I do urge members to reflect on what she said. I'll just quote, though, from Ruth Hughes, who's a barrister specialising in mental capacity law and inheritors. And it refers back to the point that my honourable friend and I discussed in an earlier session about the clear opportunity that the bill affords to people to seek an assisted death for the sole purpose of saving their family money. This barrister says, quote, if the bill is passed, then this will lead to some of the most vulnerable people dying for others' financial gain. That is certain. Although in general I would, of course, accept the importance of the presumption of capacity, in relation to assisted dying, I consider that the burden of proof for capacity should be reversed so that it is necessary to establish capacity to decide to die positively, as the amendment proposes. For this very obvious reason, there is a clear financial advantage for family members and many other, I'm afraid to say, distressing motivations that people might have that are not intended by the mover of the bill. It does feel absolutely appropriate that we reverse the burden and have a much higher test of eligibility than afforded by the Capacity Act. And I just want to make this point. I don't know how honourable members feel about it. Because I know a lot of people don't accept that we're talking about suicide here, even though suicide is what is in the terms of the bill. We're amending the Suicide Act. The assumption of capacity in taking your own life, which is what is proposed if we adopt Clause 3, we're proposing that you have capacity if you end your own life. That implies directly that somebody who is standing on a window ledge or on a bridge about to commit suicide is assumed to have capacity, assumed to be making a rational decision which other people should support. And I say this directly because I do think there is a direct read across with the whole topic of suicide prevention, which obviously we all strongly believe in. How can we say that somebody who is about to take their own life, unassisted, doesn't have capacity, isn't making a settled, informed wish? On which case, why should we stop them? Why should we try and wrestle them back from the edge? Happy to give way. And happy to give way.
Point on this: when people are in, often the term used is crisis, which would indicate that they aren't in a situation where they have. I just don't see how we can think that it's reasonable to make a comparison between these two things. They're entirely different, and I'm sure everyone here would broadly agree with that. I think on this one he's sort of on his own. So I don't know if you might be able to sort of offer any further insight into why he thinks that two sort of wildly different situations, one in a medical context where people have got all the safeguards, all that layer of security and that checking is analogous to someone who might be doing something in a moment of desperation.
The connection is explicitly in terms of the bill. The bill disapplies the Suicide Act, the clause 2 of the Suicide Act, which makes it illegal to assist somebody to commit suicide. It says that that clause no longer applies. What this bill does is assist people to take their own life. I won't use the word suicide because people don't like it. Now, there are other eligibility criteria. I totally acknowledge the honourable gentleman's pointing out that you have to have a diagnosis of terminal illness. That's not the point I'm making. I'm making the point that according to Clause 3, we are saying that somebody who wants to take their own life has capacity, according to the very low bar of having a settled, informed wish, with the assumption that they have capacity. We are assuming capacity in the person who wants to end their own life. And I suggest that presents a real challenge to our national suicide prevention strategy. So I'll leave that point, but I welcome any challenges to it.
I just would question whether he is making a false equivalence here in the very title of this bill relating to terminally ill adults.
Well, there are huge challenges around definition of terminal illness, as we have already acknowledged. But if the Honourable Lady thinks that somebody who is terminally ill should be allowed to jump off a bridge or out of a window without anybody saying, wrestle them back, then she should say so. We think that it is, whether you have capacity, whether you are in your right mind or not, you should not be ending your own life. That is the settled view of this country. That is what the law determines. And currently it is illegal to help somebody to do it. We're proposing to change that, to enable you to help to help somebody to do that, in a medical setting. But the implication of Clause 3 is very clear, that if you have the settled wish, then ending your own life is something that we regard as an acceptable thing to do. So it's going to be very, very difficult to apply the principles of national suicide prevention when we've acknowledged that suicidal people have capacity. So I'll leave that point, because it's not one that I'm receiving a great echo of affirmation from. But I haven't heard the objection to it, other than a lot of head shaking. Right. The argument made by the honourable gentleman about reversing the burden of proof. The challenge we have with the Mental Capacity Act is that it has what's called the 51% sure approach. So basically, if it's more likely than not that the patient has capacity, then they should be regarded as having capacity. I invite the committee to consider whether they're happy with that 51% sure test, and whether it would not be appropriate, given the severity of what is being proposed here, given its irreversibility, and given all the challenges that we acknowledge around the potential for internal coercion and pressure, it would not be appropriate to raise that threshold. And I don't want to repeat the points made by my honourable friend for Reigate about the value of the Amendment 49 in the name of the member for Runnymede, but he does indeed invite us, he forces us to be clear. And I noticed nobody responded to my honourable friend's invitation to say, is this what we mean by Clause 3? If we reject Clause 49, because Clause 49 requires the bill to specify that the principles of the MCA apply, which is that the burden of proof is that the patient has capacity. We will allow unwise decisions, and we will support decision-making even for those with learning disabilities. That is what Clause 3 will do if we don't amend it in the ways that we're proposing. And we're not going to move Clause 49, but I support the principle there. Let us be clear what we are doing here. Allowing people with learning disabilities to make unwise decisions and to assume capacity in all cases. Let's be honest about what we're doing if we propose to proceed with Clause 3 unamended. If we do... Happy to give it, yeah.
Just a very quick note on that point, and I'm grateful for him giving away. There is an upcoming Amendment 339 in Clause 4, which will address that specific point. Would you be, again, you've been asked a number of times today, would you be satisfied if that particular amendment was passed?
Remind me of the detail of the amendment.
It's essentially, the amendment would require that if a person is autistic or has a learning disability, they must be given accessible information in sufficient time to consider it. Additionally, there must be at least either a supporter or independent advocate there. That's going to be moved later on by my honourable friend back Silver.
Yes, I'm very, very grateful. I would indeed support that, and I think that will go a long way to addressing the concerns that we have here. And let me, and I'll come on actually in Clause 4 to some suggestions around how we can make sure that people with learning disabilities are properly supported, and particularly people with Down syndrome as well. But just to finish, Mr. Chairman, I want to speak to Amendment 50 in the name of the member for Runnymede. If we're going to proceed with the MCA, what is relevant? We need to have it on the face of the bill that to ensure the standardisation which honourable members have
confidently asserted happens anyway, but the evidence we've presented with demonstrates that it doesn't happen in all cases. So let us be much more explicit about the requirements that are needed. We should specify the minimum of what needs to be understood for capacity, including understanding the likely process of all treatment options, including non-treatment, prognostic uncertainty. It's not acceptable, in my view, to have all of this worked out by later by clinicians. Parliament must clearly say at this stage what is important, and it would be good to know if members looking at the quite extensive terms of Amendment 50, which is on page 2 of the amendment paper, what in this list they would object to, why any of this should not be included. It doesn't change the MCA, it preserves the integrity of the Mental Capacity Act, it simply specifies more precisely, it gives a clear guidance to doctors to ensure that they do the best job they can. And lastly, it does include in there reference to ensure that the patient must have full understanding of the consequences of requesting assistance to end their own life. So the potential for medical complications at the end, and that's a point that's been touched on a little in the debate, but I might quickly say a word on that. It's very, very important, in my view, that we are clear about what the patient should do, what the doctor should do, what the patient is entitled to do, what the doctor will do in the event of complications at the end. And this is not an abstract question. The Association of Palliative Medicine gave evidence to us saying, I quote, "It's important to highlight the lack of scientific evidence for the effectiveness, failure rates or complications of any approved substance." And they point out how the proposals in the bill fall quite short of the usual practice of approving treatments in the UK, which mandates careful assessment of drugs and their combinations. We don't know how that's going to be applied in this case. And so it's a point for later in the bill, how we consider what drugs should be used. But it is relevant, I think, at this stage to insist that patients are made fully aware of the drugs that will be used and the potential complications. And I will in one moment give way. I just reference Oregon, which we often refer to as an inspiration for the bill. Law in Oregon requires the applicant to be fully informed by the attending physician of the potential risks associated with taking the medication to be prescribed. So it might be worth considering that. Just to complete this point, Professor House, in evidence to us, pointed out that informed consent, which is obviously the principle of the bill, is not really specified properly. I quote, "The doctor is required to ask the person what they want to happen in the event of complications without having previously explained to them what these complications might be." So I think it's quite important that we do specify that those complications should be explained clearly at the outset. This is not, as I say, not an abstract point. I just want to quote from Dignity in Dying, my least favourite organisation, who they talk about the importance of Sarah Wooten, who's the chief executive, wrote in her book Last Rites, "We have to move away from idealised, sanitised nursery rhyme accounts of what death can be, towards truthful, no bullshit, plain spoken explanations of what should happen, what could happen." I don't think they applied that test when they were putting those disgraceful adverts in the tube showing people dancing around their kitchens anticipating their lovely death. But she's right. She's right here. We need to be very clear about what actual death can be like with these drugs. And I do want to end with just a reference to the work of Joel Zivert, American academic, who's looked at the only proper study that can be done into people who have been given lethal drugs to die, which is people who've been executed in the United States using any of the drugs that would be used in this case. Because, of course, it's not possible to do many studies into the after effects of people who've had an assisted death. But there have been some studies on people on death row. I will give way to the honourable gentleman in a moment. His point is that there is real evidence of what looked like trauma and distress and pain suffered by people as they died, even if they themselves looked peaceful, because often the first drug that's administered is a paralytic. So you are rendered immobile, and you may look very peaceful, but it is not. It is evident that in some cases there is real distress going on beneath that peaceful exterior. So we need to do a lot more work on understanding what the drugs would be used are and what the effects would be, and this needs to be properly explained to patients. All of that would be captured in the in Amendment 50. I was going to end there, but I'm happy to give way first to the Honourable Gentleman.
Just very briefly, as a thank you for giving way as well. And this is a whole different area that we're talking about. But I would say that as a medical professional, if you are gaining consent to a treatment, it is in your code of practice under the GMC that you explain all these things. Now, if we don't need to write it in the Act, that's already in existence. And I think we do, one of the a more general point here is there's a lot of stuff that is already in the public domain and the way doctors behave that doesn't need to be restated in this Act. And the more we write, the more likely it is it will be less safe for patients. So I would keep it very simple.
I really want someone to explain this point to me. How can it make it more unsafe for patients to state explicitly what the safeguards are? How can it possibly make it harder or more dangerous if we specify what, as the Honourable Gentleman says, is good practice currently, which the best doctors already do? And, I mean, I respect greatly him and his medical practice himself, but is he really saying that every doctor conforms perfectly to the to GMC guidance? I mean, there are obviously clear problems with the way some doctors operate, and this is uncharted territory. Surely for their sake, as well as for patients, it would be appropriate to specify explicitly how doctors should conduct these assessments and what communications they should make and what patients should be properly informed of. I cannot see how that makes it more dangerous.
Thank you for giving me. Just very briefly, just to concur with what my honourable friend, Member Stroud, has said, I think the point he's making, and I've done a lot of research into this, believe me, is we do have the GMC, we do have the BMA, we do have organisations who represent medical practitioners, and they have very lengthy codes of conduct and behaviour codes and such like. And what we can't do, and I've tried, believe me, is put all that on the face of the bill. But we have to be cognizant of that in some of the amendments that we're making.
I'm very grateful, but I would challenge her, and I would really welcome her response to this. We clearly can specify some things that can be done, and that's what, it's half a page, what my honourable friend from Runnymede has done with Amendment 50, to clarify explicitly what information the patient should receive and what they should properly understand. How does including this list of pieces of information make the bill more dangerous for patients? I invite her to intervene.
I'm very happy, if I may, Chair. Yeah, I'm not saying that this amendment would make it more dangerous. It would overcomplicate things. And I think that's the point my honourable friend was making. And I think we have to have a very clear piece of good law. And I think the bill covers the points in that particular amendment and in other amendments that have been put forward in good faith. I fully appreciate that. I think it's the clarity of the law that sometimes has to be the focus. But I absolutely concur with him in terms of safeguards. But I do feel, Chair, unfortunately, we're probably never going to get to a point where there's a bill where he is happy with in terms of the level of safeguards, and maybe he's prepared to acknowledge that.
Well, it's unlikely, I'm grateful, it's unlikely I would ever vote for an assisted dying law, but if we're going to have one, what I want is to make it as safe as possible, which we all want. And on those terms, in the spirit of a bill that is going to pass, I'm asking her, why not include these specific pieces of information? She says it wouldn't make the bill more dangerous, but it would overcomplicate it. Well, again, how does it overcomplicate it? To add a few clauses specifying information that must be clearly communicated. Happy to give way.
I mean, Amendment 50 requires that whoever's assessing capacity is able also, not just medically to assess capacity, but also to understand the legal implications. I mean, the final point of the amendment says that they have to understand what the insurance implications are likely to be. That would mean they'd have to inquire into the individual's financial circumstances. They possibly might need to understand what provision they've made for their family. And it also references what the designation of death is likely to be, which again requires them to, I suppose, decide what they're there and then what they're going to write on the death certificate when it happens. That I think the point is, as the honourable gentleman said, much of what is in 50 is already either within the bill or implied. As ministers have said before, we have a duty, Mr. Chairman, to the statute book not to embroider it to the extent that it becomes overcomplicated and unworkable. I don't think any of us argue with any of the points necessarily in 50, other than perhaps that last one about legal expertise. But as I say, clarity leads to certainty, leads to safety.
Thank you.
Well, by that logic, the safest, clearest bill would be one which simply authorised an assisted death without any of these checks whatsoever. So, I mean, to his point that this requires the doctor to discuss with the patient all of the implications of their death, I think that's perfectly appropriate. And in fact, if that isn't being done at some stage in the course of the process, if that's not clear in the bill, it absolutely should be. Otherwise, how can we be sure that the person is making a settled, informed decision with all considerations taken on board? So I'm sorry if it imposes a little extra burden on the doctor. It's one of the great challenges of this bill. If we're to do it properly, if we're genuinely to make it a bill that is strong in its safeguards, a whole lot of people are going to have to do a whole lot of work. It's going to be a huge demand on all parts of the public sector. So this is required, I'm afraid, and I don't accept that the content of this amendment is either already in the bill or implied in it. There might be some remote piece of GMC guidance which touches on some of this, which you'd hope would be properly applied. But if so, and I appreciate his point about embroidery, nevertheless, I think in this case it isn't embroidery, this is upholstery. This is necessary for the bill to be strong.
The Honourable Gentleman give way. I just wanted to pick up on a point he made very briefly before the previous intervention about the rights of the doctor themselves. And I think that's a really, really important point that we don't really necessarily consider enough. We talk a lot about the rights of the patient, quite rightly, but actually what this bill is going to provide is the means by which another person can get involved in someone's death. And it's really, really important that the legislation protects that person's rights as well, the rights of the doctor involved. And I just wonder if he could perhaps expand on the fact that whether he agrees with me that providing greater clarity as to the standard required to assess capacity helps the doctor, helps them to protect their own rights, perhaps in response to a further legal challenge from families. And that in actual fact it's really, really important that we consider the rights of the doctor as well as the patient.
I'm very grateful to the Honourable Lady. She's absolutely right. It is an interesting irony of this bill that actually it's presented as the free choice of individuals. Actually, it imposes all sorts of obligations and repercussions on other people. The very term assistance conveys that. And there are many other people who will be affected by this decision to take an assisted death. And she is right that it would be very helpful for the doctors to be confident that they've done their job properly because they've got a clear list of communications they're expected to make. I do, however, point out that my understanding is doctors are indemnified against legal challenge in consequence of decisions they make around this, which I think is an interesting point and one that I'm uncomfortable with, which we will come to later in the bill. Nevertheless, leaving kind of lawsuits out of it, from the point of view of the doctor's professional conduct and their peace of mind, as it were, I think it would be very helpful for them to have it clearly specified what information they are required to convey. So I'll leave it there, Mr. Chairman, with the observation that, grateful to members' interventions, I think I appreciate the good faith and the good sense that has been spoken, but I haven't yet heard any kind of reason, other than the possible one of it's otiose. It's a question of, not necessary. I don't think that is a sufficient reason to object to a clause, I'm afraid. We shouldn't be objecting simply on drafting grounds. They can be tidying up exercises later if there's repetition. But I haven't heard objections to the content of this amendment, and I would very much welcome members' support. But why don't I give way before I stop?
Thank you to the Honourable Member for giving way. Would he agree with me that this amendment ultimately aims to provide clarity, and that ultimately clarity leads to safety, not the other way around?
I'm very grateful, exactly. I think a few more words of clarification should not be regarded as burdening the bill or creating bureaucratic obstacles for doctors and patients. It actually specifies more explicitly what is going on here. It's almost akin to the Amendment 181, I think it was, that had those dangerous words for the avoidance of doubt. But that is essentially what this is doing. But it's going further because it is actually imposing clearer obligations on doctors to do their job properly. And I'll end there, Mr. Chairman.
Jake Richards.
Thank you, Chair. Much has been covered both today, but the issue of capacity, Chair, was debated at length when the committee were considering Clause 1. I do have some observations. Firstly, I'm sympathetic to the assertion that there should be changes to presumption and burden. Those are things that I've considered. Those are things I've spoken about with the sponsor of the bill. Those are things that I've spoken to with experts who gave evidence to the committee outside of committee. It's something that I've spoken about publicly as well. I'm very sympathetic. And at the heart of this is two options. One, to change the burden and presumption in the Mental Capacity Act for the purposes of assisted dying, rewriting 20 years of case law, medical practice. There is certainly some value to that, but that would be a radical departure from current medical practice, and there are other concerns with that. Or the alternative is to create rigorous processes and training around the Mental Capacity Act to ensure that it is implemented properly. And I do, after some reflection, on the side of the latter for a number of reasons. Firstly, I accept that there is debate amongst psychiatrists as to this. We've heard evidence from some who deem the Mental Capacity Act not to be suitable for this new realm, and I do accept it's a new realm and we're entering new grounds, and I'll come back to that point. But there are also many psychiatrists and lawyers who work in this area who would deem it uncomfortable and unnecessary to depart from the Mental Capacity Act 2005. Secondly, there is an oddity to a change in presumption here. There is an oddity for someone to have to prove that they have capacity to fulfil their own desire. And that oddity is one of the reasons why the Mental Capacity Act is drafted as it is. Partly, and there is two sides of this coin, partly to ensure that there is no discrimination, partly to comply with the Human Rights Act and human rights more generally, and partly to ensure that we do not end up in a medical situation which is patrician, where medical doctors are taking an intrusive view of capacity rather than meeting the individual as they are. And secondly, this bill has, when amended, and I'll come back to the amendments that are to come that I get some comfort from, does offer further safeguards than the Mental Capacity Act. So Amendment 5, which will amend Clause 9, subsection 3, does place a further level of assessment in this area. And it's a really important amendment. The sponsor of the bill has said that she will support it. I think all members of the committee have indicated that they will support it. If there is any doubt, then there will be a further assessment by a psychiatrist. That goes some way to reassuring me that it is not therefore necessary to rip up the burden or change the presumption in this area. I also want to make an observation on this point as to burden of proof, presumption, and the nature of the assessment. Because Professor Whitty clarified his evidence. And it's right that the burden doesn't change, the presumption doesn't change, but of course the nature of the assessment changes for any given circumstance. That's right. And by the way, any individual, every assessment for capacity will be somewhat different. That is why Amendment 50, in my view, is too prescriptive, and I'll come back to that. Of course, if you're considering cases such as deprivation of liberty, incredibly serious cases, cases such as the ability to conduct litigation. In my experience, I've worked with parents whose children are being removed and whether they have the capacity to make decisions as to how they present their case. Now, it's very dangerous to compare the severity of the profound nature of different circumstances, but let's not pretend that the Mental Capacity Act is not used in the most complex issues of capacity every day. On Amendment 50, again, I'm very sympathetic, and I met with the member who has put forward this amendment with my humble friend, the member for Solihull, to discuss it. And I am sympathetic, but I err again that this type of prescriptive clause is not appropriate for primary legislation when we are entering new ground. And I will just stress that point. I accept, which has been put forward by members who have perhaps opposing views on the principles of this bill, but I accept that we are entering new territory. Sorry, I know you don't have opposing principles, but have different views perhaps on other debates that we've had. I accept that we're entering new territory. I accept this is difficult. I accept that psychiatrists and medical practitioners are going to have to think long and hard about the nature of these capacity assessments, especially under Clause 9, subsection 3, when that is activated. And that work will have to be done. That work has been set out in primary legislation through some of the training clauses which have already been referred to. But there is no doubt that there will be a lot of work and consideration, but I do not deem it appropriate in my mind to have a clause drafted by one undoubtedly esteemed and experienced psychiatrist, the member who's proposed this amendment, but that work needs to be done as this bill is implemented over a 2-year period. And that work needs to be done as part of a full consultation with psychiatrists once this bill has been passed, and that should be set out in guidance. And that is what would usually happen in terms of deprivation of liberty. I don't think it's appropriate for primary legislation to set out those factors of a capacity assessment. Yes, of course.
Thank you, Chair. I thank the Honourable Member for giving way on that point. And he's saying it will take 2 years. When we talked about implementation of the MCA as it is, in 20 years it's misunderstood. Does he not see the risk of 2 years, and this is new territory, without something, capacity, without change in writing?
I think we need to be very careful when we say the Mental Capacity Act is misunderstood, full stop. Let's be very clear.
Not full stop.
Well, that was the sentence. Forgive me.
Let the member respond to the point.
I'm grateful, Chair. The evidence we've received is that this is a test. These are assessments that happen every day across the country. Now, there are more complex assessments. There will undoubtedly be areas where the assessment is not done as rigorously as it should be done. But that is why I am assured by the safeguards in this bill that if there is any doubt as to capacity at first instance, then there will be a full, thorough assessment by a psychiatrist. Now let's just think that through for a minute. So a psychiatrist trained in this area will no doubt, in my mind anyway, unless any competent psychiatrist will have a sense of what the Mental Capacity Act says and the normal test for capacity. They have been referred someone who is seeking assistance to die by a doctor who has doubts as to their capacity. Now, in my mind, it is unfathomable that that assessment at that stage will not be rigorous and will not satisfy every member that that has been done to the correct extent. Happy to give way.
I thank the Honourable Member, thank you, Chair, and I'd like to absolutely agree with him that in most cases, but there are 10 cases that did go to the court, and 9 of those cases, young girls were found to have capacity, but their treatment was stopped and they're leading to their inevitable death, and that isn't included here.
Well, if I may, we're debating lots of different things now rather than just clause 3. There is an issue as to whether in those cases the individuals were found to have capacity, but we're talking about the process by which someone is found to have capacity rather than what happens thereafter. We've had that debate. I'm very happy to have that debate as well. But we're talking about the process by which they have found capacity. This is the problem with interventions. I've lost my train of thought, Chair. This is why people don't take them. Yes, I have to take another intervention.
I've got a simple point. He won't need to think while he can look at us. He can work out what he's going to say next while I'll make a very brief intervention. the point is that the referral to a psychiatrist will happen if the doctor concludes that there has doubts in their mind. So there is not an obligation on the doctor to refer. There's only an opportunity for them to do so if they conclude that there is a reason to do so. Can I just put to him the scenario, and it's not clear whether this could happen under the bill, but it could happen currently because it's not prohibited, that a private practice establishes itself providing the assisted death and providing the medical assessments and the support, and in fact right through to the end, the final act. In those circumstances, if a patient goes to one of these clinics, does he not see there might be a risk that the whole incentive of the business, even if it's a charity, will be to expedite the process, will be to tick the boxes and pass people through? Does he not consider it dangerous that there is not an absolute obligation to refer to a psychiatrist, and in fact an obligation to pass a higher capacity test than that currently under the MCA?
Just a handy household hint. Members don't have to take interventions if they don't wish to. If you want to keep
I'm very grateful,
if the member wants to keep their train of thought, feel free not to take the intervention.
That was one I was very grateful to receive. There are no. I accept the point that there are dangers of a system that somehow incentivises this. I accept that. That is why the bill has to have such strict safeguards, such strict regulations of medical practitioners in this bill to comply with the law. I don't accept the point about the mandatory referral is absolutely key. And I would have real concerns about this area of the bill unless that amendment and the sponsor of the bill hadn't made it very clear that she would be supporting it. But I take the point. Yes.
So, I thank my friend for giving me. Just in response to the member for East Wiltshire's point, would you agree with me that clause 8, subsection 6, as currently drafted, which requires the second doctor to be independent of the first, and is not a partner or colleague in the same practice or clinical team, would protect against the situation which the honourable gentleman speculated upon?
Yes. There are safeguards and mechanisms within the bill to ensure that to protect from a culture that would incentivise this practice.
Would the honourable member give on that?
No, I'm not going to actually. It's taking my rights that I've been reminded. The final point I'll make is section 1, subsection 4 of the Mental Capacity Act, and the discarding of, essentially, if the decision is deemed to be wise or unwise. And this is an issue that we've already debated, but I think is a really important one, because introducing, essentially, a best interest test into this issue is impossible, in my mind, to do without ending up with a law that discriminates against certain groups, and is essentially impossible to do fairly. I remain to be convinced, if there is an amendment that can do what I think the honourable member wants it to do, I would support it. If there is an amendment that can look into someone's mind and make sure that they are doing this for reasons that society would deem fit, then I would support it. But I think that is impossible. And the bill aims to do is to assess that person's capacity, and that they're making this decision voluntarily, and then also aims to protect from third parties and outside sources and their influence. That is the only way. That is the only way if this principle is to be adhered to. So finally, I will be voting against these amendments, but I go to where I started. I genuinely have thought long and hard, in particular about the presumption. And I have spoken to experts who disagree with me on this. But in my mind, it comes down to whether we rip up and start again in this area, or we add rigorous safeguards, practices, and processes, which is maybe a bit more boring, but actually will be more effective at protecting any patients that go down this road. Thank you.
Thank you. So, John Joseph.
Thank you, Chair.
I'd like to talk in support of these amendments. Someone who has worked in the mental health as a mental health nurse in 22 years and completed this mental capacity training many times in my career and carried out capacity assessment as part of my day-to-day job. Think that the capacity assessment proposed in the bill was not safe enough, and that was one of the main reasons I voted against during the second reading. And talking to many people who opposed that bill, was one of their concerns was about this capacity assessment. I just use, I know we talked about capacity assessment every day in this committee, and this is one of the key issues that I think we need to resolve to strengthen this bill, if this bill goes through it. We mentioned Royal College of Psychiatrists and their concerns, and one of their comments was capacity assessments are decisions, are opinions with margin of error and are time specific. A person's capacity can change. And this is where I'm going to talk about some of my experience about these margins of error. The capacity of a person can be influenced by various factors, including their life circumstances, the medication they're taking, severe pain, and also, if they have a suicidal thought due to their mental state or depression, can also influence the capacity of that decision. We in the mental health, I worked in the acute mental health units, and every day we carry out capacity assessment, and including before we let someone out of the ward, whether they are admitted to the wards under Mental Health Act, or if they are receiving treatment as a voluntary patient. If somebody wants to leave the ward, before the member of staff open the door, they assess that person's capacity. Sometimes a person say, I'm going to kill myself. But the nurse will have to make that decision before they open the door, whether that person has got the capacity or not. I know we talked about, the honourable member earlier talked about unconscious bias. So the initial capacity assessment when a person comes to a hospital is very important. If the doctor who assessed that person's capacity at the beginning and assessed to have the capacity, then the following assessment can be influenced by initial assessment. So I totally agree with the honourable member's argument earlier about the biased, unconscious bias in capacity assessment. The proposal of the bill mentioned, and many other members mentioned about, there are many occasions in this process the capacities will be assessed. But this is where I'm still not confident that each capacity assessment will be influenced by the initial assessment that is made. So these proposed amendments must strengthen that area of concern.
On that point, will you give way?
I'm happy to give way.
I thank the honourable member, and he's made a very important speech, and thank you, Chair. On the point of where members have alluded to the points in the bill, namely for where the patient would be present and would potentially have an option to be reassessed. Given the evidence that we've heard around capacity from various experts, particularly of the issue of coercion, particularly of the issue of vulnerability, doctors have told us that it takes years to build rapport with people. And actually in the second stage, the doctor has to be somebody independent that nobody's met. So how would they be able to tease out whether that person has capacity and whether those other influences don't affect them? Does he share that concern?
I thank you, the member, for the intervention. And I agree that an independent doctor coming in to assess the capacity and seeing that patient for the very first time more likely to be influenced by the capacity that was assessed at the beginning by the doctor who know the patient for many, many days or weeks or months. So this substantiates. I agree with the member's argument there. And also, I just want to point out...
Would you give way on that point?
I'm happy to give away.
Thank you. I think you can give way. Just to be clear, that the word independent is independent of the other doctor, not the independence from the patient. So they could well know the patient, and I hope that clarifies that for him.
Thank you for the intervention. And it could be other way as well. I mean, the bill doesn't clarify that the second doctor would know the patient at all. And there could be yes, that's not guaranteed. Yeah. Thank you for that intervention. And we talked about the training. All doctors, all the registered professionals who will be involved in the capacity assessment, and they will have the training. I would like to, someone who has carried out this training many times, and also would like to the attention of the committee to Dr. Rachel.
Order. It being 11:25 a.m., the committee is now adjourned until 2 p.m. Order.